It was basically character assassination and the destruction of my livelihood. From one day to the next, no salary anymore. Anyone can imagine what that's like. So if you're sitting there listening to this video, let's say you get several thousand euros at the end of the month, and suddenly from one day to the next, it's gone. You could actually say that the University of Bonn might have hired me as a dissident voice.
Are lawyers, including judges, also contributing to the destruction of democracy in Germany?
Gegen den Strom. Zur Person.
Hallo bei Gegen den Strom. Ich zeige Ihnen Positionen.
Welcome to Against the Current. I'm here to show you positions and perspectives that the propaganda media keep hidden. Her life was destroyed, but she built a new one, better, and entirely on her own. She's one of Germany's most prominent social scientists. Her books are published around the world and translated into many languages, and she embodies something that seems to have been lost in Germany: a democratic fighting spirit. Ulrike Guérot was dismissed from the University of Bonn over alleged plagiarism. She took the case to court and lost in the labor courts. Now, Ulrike Guérot is filing a constitutional complaint. Hello.
Ulrike Guérot, Verfassungsklage. Hallo.
Hello, Patrik.
Why are you filing a constitutional complaint?
First of all, I'm really glad to be here and to have this conversation with you. Maybe we can just mention it briefly. Last year, I gave the laudatory speech for the alternative Karlsruhe, where we stood together for peace. I just wanted to say again that it was a wonderful experience. So why am I filing a constitutional complaint? Well, because I'm not only disappointed by the decisions of 3 labor court instances. Of course, disappointment is one thing. But my lawyers and I have well-founded reasons and plenty of arguments to believe that fundamental rights were violated in this legal process. At this point, we have to understand that at the level of the Constitutional Court in Karlsruhe, the case is no longer about labor law decisions and certainly not about plagiarism. What it's really about now is the right to be heard and the right to a fair trial, as guaranteed by Article 103 of the Basic Law. That right to a fair trial includes, for example, the ability to present expert testimony, to make your own case, to have your witnesses heard, and to have experts assess the matter. All of that is part of a fair process. Article 103 of the Basic Law, in turn, is also derived from Article 20, paragraph 1. And then there's Article 3, which contains the so-called prohibition of arbitrariness. And of course, academic freedom under Article 5 is also affected when, as we argue, a professor is dismissed from a university for flimsy or pretextual reasons. That kind of thing, if I may put it this way, brings back memories of darker times in German history. So we're now invoking Article 3, Article 20, Article 103, and Article 5 to assert violations of fundamental rights. And in this constitutional complaint, we argue that the case goes beyond the Guérot matter, beyond me and my personal situation, and is therefore of broader social relevance. Why is that? Because in that process, there was a kind of shift in the legal framework, meaning there were no experts involved who could decide whether it was plagiarism or not. They could have invited a few German literature scholars to say yes, no, or maybe. In any traffic accident, judges call in experts who say the skid mark is 20 meters long, so you're at fault. But in my case, that didn't happen. There were no experts at all. And that's why the question of whether I plagiarized or not was turned into a legal issue. And because it was declared a legal question, The judges then basically decided on their own, one could also say arbitrarily, that it was plagiarism. Now, if we look at this systematically from a legal point of view, you're turning a factual question into a legal one, and then you answer it on your own authority. If you take that logic further, the door to arbitrariness would be wide open. Then judges could soon say, water now boils at 50 degrees Celsius, and that's not a factual question. We won't listen to the physicists. We're declaring it a legal question. And that's why, in our view, meaning in the opinion of my lawyers, the systematic structure of the legal order, the very legal framework of the Federal Republic, is being affected. And because individual rulings, like in this case my own, set a precedent, other judges could later refer to my case in their decisions. Court rulings have legal force, and our argument is that this would, in essence, amount to a shift in legal doctrine that would seriously damage the legal stability of the Federal Republic, and through Article 3, the prohibition of arbitrariness, would open the door to arbitrary decisions.
So your argument is this: a factual question is turned into a legal one, and the judge decides on his own whether this is a case of plagiarism. But he should have consulted experts.
That's the argument we're making, but the Federal Labor Court sees it differently. So just to explain the steps again for the viewers, the university terminated my contract. Maybe I should mention here that a few days ago I uploaded 4 videos, each about 20 minutes long, about my case, what I call the Causa Guérot. In those 4 videos, I go through everything in detail, step by step, in chronological order, explaining what happened and when. So, if it's hard to follow every single detail here, you can watch the full explanation there. But what happened? Well, I was fired. And in my view, not because of plagiarism, but because of a book. We can come back to that in a moment. Then the Labor Court in Bonn, in the first instance, confirmed that the dismissal was lawful. So I appealed, went to the Regional Labor Court in Cologne, the second instance, and that court also upheld the decision from Bonn, saying again that the dismissal was lawful. At the same time, I'd say, the Regional Labor Court in Cologne basically locked down its decision and didn't allow it to be appealed further. That means for me, it was basically over last October. I had lost in 2 courts, and the ruling wasn't open for appeal. In a situation like that, and I should add that back in October, I was honestly pretty close to giving up, because it really seemed almost hopeless to get anywhere from there. You only have, technically speaking, sorry Patrik if I get a bit technical here, just one option left. You can file what's called an appeal against the denial of admission. Well, first of all, you have to file a complaint that the ruling wasn't allowed to go to appeal. So now it's only about the technical side, not about the ruling itself. And these complaints about non-admission are basically on the 3rd legal level, meaning the Federal Labor Court, the Federal Social Court, or whatever other federal court applies. That's where you have to file them. It's a technical legal specialty, and there are only a few lawyers who focus on that. I found one of them, and he's handling this complaint about non-admission. That means we're filing with the Federal Labor Court and saying that the State Labor Court should have allowed the appeal. Why? Because the ruling is so unusual, so far outside normal labor court practice, that we see several established labor law standards basically being overrun. And that's why one could, well, you can do that. A labor court can say this case is truly exceptional and so on, and therefore we're departing from existing case law. In this case, we're departing because, well, that's possible. But in situations like that, it's actually more common for the court to allow an appeal precisely because it's deviating from established case law. In this case, the court deviated significantly from existing precedent, but the ruling was not opened for appeal.
Aber das Urteil wurde nicht zugelassen. Ja? Und dagegen haben wir dann eben beim Bundesarbeitsgericht Beschwerde erhoben mit dieser
So we
sogenannten
filed a complaint with the Federal Labor Court,
und haben
this so-called appeal against non-admission, and we argued that it should be accepted, among other things because there hadn't been any expert hearings in either the first or the second instance. My witnesses weren't heard, and there were no external experts who were even asked the basic question, were there actually any cases of plagiarism? Then, the Federal Labor Court ruled on this appeal against non-admission, and in that process, well, I should say I'm not a lawyer, but in fact, the Federal Labor Court could have just rejected it in a single sentence, saying, we dismiss the appeal against non-admission.
Wir weisen die Nichtzulassungsbeschwerde zurück. Interessanterweise hat das Bundesarbeitsgericht aber mit
Interestingly, the Federal Labor Court responded with 21 pages. That's really unusual. So, apparently, they felt compelled to justify rejecting my appeal against the denial of admission. And in that justification, there's something my lawyers consider a major legal error. Because in that rejection, the Federal Labor Court says that the Cologne Regional Labor Court, remember the issue was about the hearing, why there was no hearing, was entitled to reclassify the question of whether there was plagiarism or not from a question of fact into a question of law. And once it's treated as a question of law, the Regional Labor Court can then decide on its own, saying, all right, I can decide this myself, so it was plagiarism.
Okay, ich kann das jetzt selber entscheiden, also war es Plagiat. Und dann bestätigt das Bundesarbeitsgericht.
And then the Federal Labor Court confirms, after first legitimizing the reclassification of a factual question into a legal one, as the Cologne Regional Labor Court had done, that this was correct. And then the Federal Labor Court says, and therefore it was plagiarized. Let's take a step back for a moment for everyone watching who finds these terms a bit complicated. It's kind of like saying, the question of whether water boils at 50 degrees Celsius is no longer a factual question we'd ask physicists, but now it's a legal question. And because it's a legal question, the judges can decide it themselves and simply declare, all right then, water now boils at 50 degrees Celsius.
And you're saying, together with your lawyers, that this self-authorization by the Regional Labor Court, which was confirmed by the Federal Labor Court, isn't constitutional. To what extent, you've hinted at it, are constitutional rights being affected here?
Genau, also erstmal würden wir ein bisschen schalkhaft jetzt mal sagen, wir sind dagegen, dass Richter darüber entscheiden, ob Wasser bei 50 Grad Celsius kocht, ja, weil es relativ naheliegend ist, dass diese Fragen, also dass Gerichte judizieren sollten unter Anhörung von Sachverstand. Warum glauben wir, dass Grundrechte hier, also es geht ja einerseits um eine Grundrechtsverletzung, das ist, wie gesagt, kein Recht auf Anhörung, 103 und faires Verfahren, aber wo liegt sozusagen für alle Bürgerinnen und Bürger der Bundesrepublik, wo läge
For all citizens of the Federal Republic, where exactly lies the problem with this kind of legal shift? In our view, if this ruling were to stand, it would set a precedent, one that could allow future decisions to be made without consulting expert knowledge.
Ohne Anhörung von Sachverstand getroffen werden können. Nehmen wir jeden Verkehrsunfall.
Take any traffic accident. Normally, you have a crash, and then judges have to hear from experts. How long was the skid mark? What does the dent look like? Who's at fault? Or take a medical case, a case of malpractice. There's an expert, and the judge makes a decision. Or take a construction error by an architect, and the building collapses. Again, experts are called in, and that's what the judge bases the decision on because the judge doesn't have expertise in architecture, construction, traffic, medicine, or any of those fields. That's exactly what the rule of law is about, and that's what we're talking about when we say fundamental rights are being violated. The rule of law means a fair process.
Ist ein Rechtsstaatsprinzip ein faires Verfahren und ein faires Verfahren setzt Sachverstand und Sachkunde voraus.
A fair trial requires expertise and sound judgment. So if you take that expertise and judgment out of the process and tell judges they can decide factual issues more or less on their own, if not outright arbitrarily, that would be a fundamental or at least a serious shift in legal doctrine. And that's why we believe my case isn't just about my own basic rights being violated, it's also a case that could potentially open the door to a shift in legal doctrine, one that sooner or later could affect any citizen.
Are you saying that in your view, judges, labor court judges in particular, have put themselves at the service of political power?
Well, that's not what I want at all. Honestly, I don't think those processes work in a way that puts them in service like that. I mean, first of all, judges are public servants. Formally speaking, that's what they are. They're civil servants. They get a salary, that's their compensation. And they serve the state by defending the Constitution and the law. That's why they're judges. They sit in independent courts, and their duty is to ensure legal certainty. That's what makes them public servants. So the real question is, what actually happens in cases like these? I don't actually believe that. Personally, I really don't think that happens. That someone picks up the phone and says, you have to decide this way or that way. I don't believe that, no. What I do believe is that in cases like mine, where there's a certain amount of public attention, there's also a kind of social pressure and a kind of public prejudgment. And judges, well, they're not outside of society. They read the newspaper, they're part of the community, they play golf somewhere, people whisper things to them, they hear things. Do you see what I mean? I really think these are personal and independent decisions. And in the end, they're decisions made, how should I put it, before one's own conscience. That's what it ultimately comes down to. So, to explain briefly, your question is very important, Patrik, but in the video I recorded about the case, the Guérot case, I actually mentioned the judges of the Federal Labor Court by name. Why did I do that? Well, first of all, these are public rulings. Anyone can look them up. They're available on the Justice Portal. Anyone can read the decision online, and the names are listed right there. Well, it's done in the name of the people, right? It's part of the justice system. It's public. The judiciary is a public matter. And what I really want to say is this. It wasn't a decision made by the BAG, the Federal Labor Court, as some kind of single entity. Who is the Federal Labor Court, anyway? In the end, it's made up of different judges. They each have their own cases, and each one can decide this way or that way. Every judge always has the option to say, I'll decide it like this, or I'll decide it like that. That means, in the end, Hannah Arendt said this too, in any group dynamic, what really counts is your own conscience, what you personally do. That's what matters to me. And at that moment, the real question is, what's going through the judge's mind when they make a decision like that?
Was denkt der Richter, wenn sowas entscheidet? Also ich würde schon vermuten wollen, das kann ich ja nur vermuten.
Well, I'd have to assume, and that's really all I can do, that the judges at the Federal Labor Court had or still have the expertise to assess this case properly. In my case, they made a rather unusual decision and signed off on it. So now the real question you'd have to ask them is, why did they do that? Did they do it because they got a phone call? I don't think so. Did they do it because they were personally convinced that in my case, such an unusual decision needed to be justified? And if so, why did they do it? I can't answer that. You see what I mean?
As a political editor in Schleswig-Holstein, I've often seen how top judicial positions were negotiated between the parties in the state parliament. Something like, you get the attorney general and we'll take the president of the administrative court, for example. Do questions like that play a role here, where a judge might feel that his career is over if, in the Baab case, he doesn't rule the way he's expected to?
Wenn im Falle Guérot nicht im Sinne des herrschenden Meinungsklimas entscheidet.
Das ist eine ganz schwierige Frage und
That's a really difficult question, and I honestly want to avoid passing judgment on anyone myself. What I think I'm noticing is that here in the Federal Republic of Germany, we've found ourselves in a pretty difficult social climate over the past few years. Let's put it that way. And this difficult environment comes with a strong pressure to conform. There are these unwritten rules. People just know by now, better not say anything about this, better not say anything about that. Everyone knows the hot-button issues in society: Gaza, Ukraine, migration, climate, gender, and so on. These are the unwritten rules.
Ja, das sind ja ungeschriebene Gesetze. Die sind ja noch fast schlimmer als geschriebene Gesetze, ja?
They're almost worse than written laws. And then there's this pressure to conform. That's one thing. And I think a lot of citizens notice that. You can even measure it. We've got surveys showing that more than half of Germans now believe freedom of speech is no longer protected, and so on. What you're describing are processes. Let's say in the past you might have called it camaraderie, a bit of back-scratching. Let's not act surprised. I think it's always been that way. I'm from North Rhine-Westphalia. We always knew the state run by the Social Democrats and then the state bank and whatever else. So, yeah, there's always been a bit of dealing going on.
Ja, also wird halt so ein bisschen gedealt, ja? Ich will es nicht bewerten, ja? Also sozusagen.
I don't want to judge it. So, how should we call it? Clan structures or maybe little inner circles, something like that. You find them in the CDU, you find them in the SPD. That's just what people do over a few beers. In the old days, it happened in the beer tent. Let's leave it at that. It exists in Austria, too. I lived there for quite a while. Politics is made by people, and people make mistakes. Everyone has their vanities. Let's just leave it there. The question for me comes up when, how should I put it? It's hard to find the right words when there's a kind of socially accepted buddy system, the kind I think I still saw in the 70s and 80s. It was clear enough. People marked out their turf, the way dogs mark their corners. But it wasn't malicious. Let's put it that way.
Es hatte nichts Böswilliges, nennen wir es mal so. Wenn ich heute das Gefühl habe, dass
When I get the feeling these days that similar kinds of deals or buddy arrangements or what you just mentioned are meant, and that's increasingly the impression I have, to keep a system going that no longer works, or to sweep things under the rug that really need to be dealt with, well, when it goes beyond just a casual, you take that position, I'll take this one kind of thing, and instead takes on a system-stabilizing role that helps suppress or hide wrongdoing, then I think a line is being crossed. It shifts from what you might call a more or less natural kind of human behavior to something that, interestingly enough, Margareta and Alexander Mitscherlich described back in the 1950s in their book, The Inability to Mourn, as a community of guilt.
Eine Schuldgemeinschaft genannt haben. Ja, also es entsteht dann ein System, wo
So what happens is you get a system where everyone knows something went on that wasn't clean, and now we all have to cover it up, because if it comes out for you, it'll come out for me and then for them too. And we don't want that to happen. That means a society starts sliding into a kind of shared guilt, where everyone hides the wrongdoing of others because their own might be exposed. And that, in my view, is a very different process from what you might call the usual, let's say, beer tent camaraderie you sometimes see in politics.
If judges, labor judges, belong to this community of guilt, as you call it, that shows the separation of powers in Germany no longer works, meaning the division between the executive, legislative, and judicial branches.
Yes,
I'd say so. We could see that quite clearly, to be honest, in several of the court rulings related to COVID. We saw that courts often relied on a government agency, in this case the Robert Koch Institute, while other experts weren't really able to have their views considered. And we even saw that when the RKI files were made public, meaning some rulings should actually have been withdrawn because the data had changed, changed, those rulings still remained in force.
Geändert hatte, dass die Urteile dann weiterhin Bestand hatten. Das heißt, wir haben da schon gesehen, dass die Gewaltenteilung, also ein Gericht, das sich sozusagen dann auf
Separation of powers, meaning a court that, so to speak, relies on government agencies, well, that basically means the judiciary and the executive start to blend together. That's how I'd put it. The process we're describing here, and thanks for the questions, I think we need to add one more thing. When I used to say it was a bit like backroom deals at a beer tent, and now it's become a systemic, almost cemented form of concealment that shows there's been a shift. And I think we also have to add that all of this is now happening under completely different digital conditions. So, this whole thing about algorithms, about the platform economy, about control, this algorithmic control, we really have to keep that in mind when we describe and analyze these kinds of processes. How was it in the past? How is it today? And why does it hit us so strongly now that we all feel like the courts just don't work anymore? What are the actual criteria for that? I think the platform economy plays a big role here, and of course the broader systems of regulation, like the Digital Services Act, the European Union, and so on. What I mean is, in any political or judicial system, mistakes will always happen, simply because we're human. We make mistakes everywhere. But when these kinds of cemented structures, this sort of shared sense of guilt, start to reinforce each other, and the systems themselves become more and more all-encompassing. Take the Digital Services Act, for example. That's the EU, that's EU-level control, and so on. Then I think it becomes harder and harder for individuals to pull themselves out of it. And I think that's a real problem. That's why I'm not even sitting here to personally blame anyone. I'm just observing with growing dismay that these are systemic processes, and it's becoming increasingly difficult for individuals to escape them.
Are lawyers, including judges, also contributing to the destruction of democracy in Germany?
Die einfache Antwort wäre zu sagen, ja.
The simple answer would be yes. Now, I don't assume that anyone is deliberately trying to destroy democracy. No one. In fact, I'd rather think, well, it always comes down to that question. What's in it for me, right? Let's take, for example, the judge in Bonn, from the Bonn Labor Court, Dr. Daniel Kramer, a relatively young judge. I don't think I'm being unfair or saying anything inappropriate when I say that he seemed quite nervous in the first hearing. You could tell. Of course, it was a highly charged case. Now, imagine you're a young judge in Bonn. Maybe you've got 2 kids, I don't know. Maybe you're a member of a golf club or something like that. You want to keep living in Bonn. You'd like to get promoted. Fair enough. There's absolutely nothing wrong with that.
Fair enough. Selbst dagegen ist nichts zu sagen. Ja?
And then you get this kind of charged up process, and that's the moment when you have to ask yourself, do you have the strength to stand up against all that tension in society? Because there was a public presumption of guilt against me. So the judge's job would probably have been, in the spirit of the law or of public service, defending the law, to say, dear university, it's your right to part ways with Ms. Gerald, but not like this. I mean, it's really about all those procedural errors, no termination without a prior warning, things like that. He could have said that, of course, and said, look, that's what we expected. No warning, no termination. That's the golden rule of German labor law.
Keine Kündigung, keine Abmahnung, keine Kündigung ist die goldene Regel des deutschen Arbeitsrechts, ja. Da hätte der Richter ja eigentlich sagen können, mit dem Augenzwinkern, liebe Frau Guérot.
The judge could have just said, with a bit of a wink, dear university, try to get rid of Ms. Gerald a little more cleverly next time. Give her a warning first. You'll get rid of her eventually, but at least do it properly. That would have been one possible way to handle it. Instead, he validated the dismissal. Now, your question was, are judges deliberately destroying democracy? And my answer is, not deliberately. Maybe out of cowardice or a lack of backbone, or because the whole case was so charged. Everyone knows how that feels. I don't want to, so to speak, absolve the judges of their guilt, in quotes, or anything like that. It's not really my place to do so. I just want to take a closer look at the group dynamic here. You know how it goes. Everyone does. 10 people in a room, 9 say uh-huh, and one person thinks, actually that's not right. Then comes the question, do I keep quiet or do I speak up publicly against it? And most people stay quiet. You see what I mean? The question is it the individual's deliberate choice, or is it more a kind of herd behavior, like, I can't help it, I just go along? And that's what's dangerous. That's why I mentioned Nitscherlich earlier, because at some point it becomes more of a collective failure, where everyone's just asking themselves, what's in it for me if I speak up now? You know, that's the problem.
Auch ich bin ja wie du gekündigt worden.
I was also dismissed, just like you, but not as a professor, as a lecturer at the State University of Kiel. The granting of a teaching assignment is an administrative act, not an employment matter, because I didn't have a work contract. So I took the case to the Administrative Court of Schleswig-Holstein. The panel, chaired by Dr. Malte Siebert, ruled quite differently. The judge walked in and said, usually this room is empty. We're talking about the building use regulations. Today the courtroom is packed, but we all agree on one thing. This is about constitutional issues, about fundamental rights. And right away he played the chamber card. He carried out an extensive collection of evidence, which was then presented in court. A young judge had to do the preliminary work and said, this is about constitutional questions, specifically Article 5 of the Basic Law, freedom of science, freedom of information, and freedom of expression. And I won that case outright. So there are counterexamples too. Does this show a failure of the labor court in Bonn?
It's not my place to give that answer. But yes, that's exactly why I said earlier, why did I, for example, mention the names of the judges at the Federal Labor Court when I talked about the case? Because they're the ones responsible for those rulings. They signed them, after all. That's how civil service law works. There's a judgment, and there's a name behind it. It's not just the Federal Labor Court, and it's not the Labor Court in Bonn. In this case, it's Dr. Daniel Kramer. So I think it's absolutely right to remind ourselves that every civil servant, in this case every judge, is, as Hannah Arendt put it, ultimately accountable to their own conscience within that group dynamic. It's not my place to judge that. Honestly, I would have liked to see something different. That's why I just opened up that little point. The simple, almost charming solution would have been to say, Dear University, I can totally understand that you find Ms. Guérot a bit annoying, but just handle the termination properly and issue a warning. That would have been a small wink, and I think as a judge, for example, he could have afforded to do that, but he didn't. So who's responsible for that now? He is. And it's not for me to pass judgment on it. He's the one who has to answer for it, to himself and to his conscience.
Vor sich und seinem Gewissen, ja.
Die Politikwissenschaftlerin Ulrike Guérot war gut vernetzt.
The political scientist Ulrike Guérot was well connected. You worked for Jacques Delors. You were a close friend of Fiona Hill in Washington, a senior fellow at the Brookings Institution, an advisor to several U.S. presidents, and at times a member of the National Security Council. And then, from one day to the next, it was all gone. The University of Bonn wanted to hire you because of your international reputation, and they threw you out when they suddenly realized you also had dissident views. Is this case, the case of Ulrike Guérot, a sign of political persecution in Germany?
Ulrike Guérot, ein Zeichen für politische Verfolgung in Deutschland?
Political persecution is really a very strong term. I'd set that one aside for now. So first of all, it's important, thanks for bringing it up again, but the job posting wasn't just about a professorship. It was actually about building a European Policy Research Center, the CSIRC, the Center Ernst Robert Curtius, where I was supposed to take on a co-director role. And of course, there are different skill sets involved. Good scholars often sit in their ivory towers, but when you're building an institute, you also need management skills, media skills, and a strong network. And those 4 criteria were all part of the job posting. So of course, it really bothered me later on that they only came at me with accusations of scientific misconduct. Because the skill set they were looking for at the start was something completely different. Like I said, there are plenty of people who are excellent scientists, but they can't manage or don't have a strong network. Now the question is, what exactly is a network? I've worked in different areas. Since you mentioned Fiona Hill, I actually knew Brzezinski personally. Back in 2014, Brzezinski was still in Washington discussing the Maidan events at the time. But I was also connected with the socialists, and even with the fascists, you know what I mean. Politically, I was kind of networked across party lines. In fact, for me, it was always about Europe. Anyone who was involved with Europe in one way or another, I was connected with them. That included people from the Catholic Church, from labor unions, or whoever else. The question was always, are we going to have a European unemployment insurance system? Yes, no, maybe. And that always led to the bigger question, where do the European socialists stand on this? Where do the European conservatives stand? What do the Americans think about Europe? So what do you say, Fiona Hill? Calling her a friend might be a bit of an exaggeration. Yeah, but of course she was, for example, always invited as a guest to the Munich Security Conference, where I'd also been for years. And my focus was always on asking, okay, what's next? What are we doing now with the Lisbon Treaty, with the banking crisis, and so on? So I'd say it was important to me to be connected across party lines. Take Anatol Lieven, for instance. He was basically a dissident voice out of Washington, and I knew him well too. So now the question is, I'd like to frame this differently because what we're talking about here are political persecutions of dissident voices. You could actually say that the University of Bonn might have hired me as a kind of dissident voice. You have to understand this ZIRG, and that's what makes it even more absurd, really. This ZIRG had back then on its website, as its mission statement, as its research goal, we want to create a center that, from a German-French perspective, tries to rethink innovative solutions for Europe beyond the paradigmatic assumptions of the 20th century. That's basically a job description for dissent. It's like saying, could you please think differently? Not based on the paradigmatic assumptions of the 20th century. I liked that, and I had already written that utopia back in 2016.
Und ich hatte ja vorher schon 2016 diese Utopie geschrieben. Die heißt sogar Utopie. Also Utopie heißt ja.
It's actually called utopia. So utopia means, well, it's not reality, but more like a kind of draft or design. And it's already pretty dissident to say, reality isn't really working anymore. The EU doesn't function. Technocracy, something's off. So I come up with a utopia. That's already dissident thinking. And with that kind of thinking, I was supposed to head this institute. Then the war happens. Well, first came COVID. Let's not forget, that was March 2020. I started the position in September 2021, and then in October 2022, I wrote this book, Endgame Europe. I think you know it pretty well. It's the one I did with Hauke Ritz. And basically, I'm making, let's say, my second major paradigm shift. Can we put it that way? Because in my book, Europe's Republic, I had already made the first paradigm shift with the EU system. I had cleared that away in my utopia. But even though I'd had growing doubts for years before that, I hadn't yet seen so clearly that, put very simply, you can't build a strong Europe together with the Americans. For a long time in the Atlantic world, we kept talking about the Atlantic friendship and all that. But if you really want a strong, independent independent Europe, well, that's a different story.
Wenn man jetzt ein starkes, emanzipiertes Europa und sozusagen, ja, so. Ich habe natürlich über die Jahre gesehen und gekämpft.
Over the years, I've seen it and fought for it, together with people like Fiona Hill, always there in Washington. And I'd say to them, so do you Americans actually want a strong Europe or not? And over time, I had to realize more and more, no, they actually don't. But that's also a process of understanding that takes time to mature. You reach a point where you say, hey, folks, I really trusted you. I trusted that we were part of this transatlantic framework. You on your side, we on ours, but that we were building an independent Europe. And then I'd go on to explain again how the European Constitution actually works. That, in a way, was my intellectual journey over the years.
Das war ja sozusagen mein intellektueller Prozess über Jahre. Und als das dann seit dem Maidan immer
And when that stopped working more and more after the Maidan, and then the war came in 2022, and I wrote this book, that's really when I made my second big paradigm shift, if you will. I said to myself, now I get it. With you, with the United States, there's simply no way an emancipated Europe can exist. And I basically wrote that second paradigm break into the Endgame book. That's the third chapter, the one with Hauke. Just to show that what should actually be the mission of the research center, to think about Europe beyond the paradigms of the 20th century, is exactly what you're not allowed to do.
So the University of Bonn hires you for being a dissident, and then suddenly they don't like it after all.
Yeah, you summed that up well.
Der Soziologe Oskar Neg.
The sociologist Oscar Necht, I know him, writes in his book about the generation of 68. Opportunism is the mental illness of intellectuals. Does that also apply to the University of Bonn?
Auf die Universität Bonn zu.
Also danke, dass du den Negt jetzt erwähnst. Tatsächlich habe ich
Thanks for bringing up Negt. Actually, I think it was in 2018 or 2019 that I co-wrote a little book on Europe with him. So thanks for mentioning that, because I really value his work. Now, about opportunism. No, I'd put it differently. I'd say opportunism is probably, as you said, the mental illness of intellectuals. Well, actually not of intellectuals. And that's why real intellectuals aren't sitting at the university. It's probably the mental illness, though that sounds a bit pejorative, of professors within the academic system. That's a different thing altogether.
Das ist nochmal ein Unterschied, ja. Also Heidegger ist ja jetzt auch schon wieder.
Heidegger is, of course, already kind of problematic to quote these days, but he once said, "Science doesn't think. Science doesn't think. Science can research an incredible amount, but it doesn't really reflect, or often doesn't. And that's why a scientist isn't necessarily an intellectual, and why intellectuals are often not found at universities, because you can do a lot of research without actually thinking about what it means. For example, that's why Dürrenmatt wrote his play about the physicists who end up in a mental institution. They researched nuclear fission, and then they thought, what have we actually created here? Maybe we'd better check ourselves into the asylum for a bit. Yeah, but you can see it across all areas of research. For example, right now, the so-called peace clauses at universities are all being scrapped. That means we're once again allowing military research at universities. There was a time when all universities had signed these peace clauses, meaning they wouldn't conduct military research or any research that serves the military. And now people think this is just about nuclear fission or something like that. But no, it also includes psychological research, neurological influence, and sociological studies. The scope of what counts as military research is actually very broad.
Sehr breit aufgestellt, ja, was militärische Forschung ist. So. Und jetzt sind diese Friedensklausel.
And now, those peace clauses have been dropped at most universities, I think even at the University of Bonn by now. So, of course, a lot of money starts flowing in, probably not directly from NATO, but kind of, well, a bit whitewashed before it reaches the universities, and then you get a research contract and suddenly you can do a lot of research. For example, you can study the concept, like we saw during the pandemic, of so-called emotional coercion or emotional nudging. In other words, how can I get someone to do something they might not otherwise do? You put a sausage next to it, the sausage vaccination idea.
Bratwurstimpfung, ja. Und emotionale Nötigung ist zum Beispiel so ein Thema, darüber wurde während Corona
Emotional coercion is one of those topics that was studied extensively during the pandemic. You could start by asking, is emotional coercion actually a good thing? And pretty quickly you'd probably say, no. It's really a way of forcing someone without actually forcing them, like you just put the sausage next to it. The moment you switch off your conscience or your intellect, the moment you stop asking yourself, what exactly am I researching here? How does my work fit into society? Once you set that aside, you can do a lot of research, a lot of science, and still not be intellectually engaged.
Und trotzdem nicht intellektuell sein.
Der Historiker Karl-Dietrich Bracher, längst verstorben.
The historian Karl Dietrich Bracher, who passed away long ago, wrote in his 1967 book, The German Dictatorship, and I quote, "The synchrisis of the German spirit with Hitler's National Revolution was shocking, not only in view of the primitiveness of the National Socialist conglomerate of ideas, but even more because of the unconditional submission to its intellectually emphasized and intolerant claim to exclusivity." And by that, he meant all professions, literary scholars, social scientists, writers, artists, and especially lawyers. Do you see at the University of Bonn, but also in the labor courts you've dealt with, that same kind of unconditional submission to power?
Diese bedingungslose Unterwerfung unter die Macht.
Well, yeah, so the question is really, are we talking about submission as a formal act or as an implicit one? But if you mean it as an implicit act, then I'd agree with you. It's pretty clear that there was a sense this dismissal had to be validated, no matter the cost. That's how we've been putting it too. And just the fact that this labor law case has already been going on for 3 years, that's completely unusual. The case files are now 2,000 pages long. If you look at what tiny little mistakes those 2,000 pages are about, well, whatever. That alone shows, as my lawyer put it, that there's probably never been a dismissal in this country that had to be justified with so much effort. And that, of course, supports your point that there was a certain submissiveness involved. But Bracher, Patrik, I really appreciate that you brought up Bracher.
Patrik, ich bin dir sehr dankbar, dass du Bracher erwähnst. Sehr.
Yes, I actually studied with Bracher back in the 80s. He was still part of that war generation. He'd been a flak helper and all that. And I think it was in 1985 that he wrote his book, The Age of Ideologies. I actually quote from that book in the videos I made myself about my case. Because in The Age of Ideologies, Bracher says that ideologies are basically a way of simplifying complex realities. Society becomes divided into opposites, good and evil in moral terms, friend and enemy, and so on. And I remember clearly that in 1986, I wrote my first really good term paper with him on Jean Bodin's Les 6 livres de la République, or the 6 books on the state. I think I got a B+ on that. Yeah, and back then, as a 20-year-old, I thought, wow, I'm getting...
That was one of Karl Dietrich Bracher's strengths anyway.
So that was an IKO? Back then, during the Bonn years, you really have to picture it. There was Ossenbühl among the legal scholars, Thomaschat, the great expert in international law, Isensee in public law, Hildebrand in history, Karl Kaiser in political science, Hans-Peter Schwarz in political science, and Karl Dietrich Bracher. Basically the whole university. It was a showpiece university, and I felt completely at home there. Just to tell that story briefly, back then, I know, nobody believes me anymore. I was with the RCDS. I ran the student election campaign in 1983 as the RCDS's top candidate. Back then, my name was still Ulrike Hammelstein, not Ulrike Guérot. By the way, on my list back then, just a little anecdote, was Bernd Lucke, who later became known through the AfD. We were both in the RCDS at the time, whatever that's worth. Yeah, the University of Bonn, back then the Bundestag was still in Bonn, so the university had a great reputation. And I'm telling you all this just to say that now, 40 years later, I'm supposed to be declared an enemy of that same university? Me, someone who really loved that place, who made the most of it, who studied there under Karl Dietrich Bracher himself and read The Age of Ideologies with him in a seminar. It's all so bizarre that I just have to say, people, how come? And maybe one more little anecdote in that context. Did you actually know that Thomas Mann also received an honorary doctorate from the University of Bonn?
I didn't know that.
You didn't know that? Let me tell you the story. I've actually never told it before. The city archivist of Bonn, who I don't know, maybe liked me, sent me some documents. Apparently, Thomas Mann had received an honorary doctorate from the University of Bonn. Then came 1936, and later the war against Russia, and so on. Thomas Mann wrote a memorandum calling for peace and understanding with Russia, and as a result, he lost his honorary doctorate. There are some really fascinating entries in his diaries about how deeply that affected him. The public accusations went far beyond what anyone could personally endure.
Jenseits des persönlich Erträglichen. Und was wird ihm vorgeworfen?
And what was he accused of? Plagiarism. A novelist. Now, plagiarism in academic work, you could maybe understand that, but plagiarism in novels, that's really, let's say, a bit strange. And from his diaries, from 2 or 3 passages, you can see that Thomas Mann really suffered from it. Then he goes to California. Yes, that's where you have Villa Aurora now, the Thomas Mann house. And then, of course, everything happens here, in this country, what happens. And apparently, in 1949, when things had more or less settled, the University of Bonn offered Thomas Mann the chance to have his honorary doctorate restored. And Thomas Mann refused.
Because he realized that moralism is just another form of opportunism.
I think so, yes.
Well, you're in good company now.
But let's be clear. I never meant to compare myself to Thomas Mann.
One of the greatest German writers who, God knows, borrowed from everywhere, just like Bertolt Brecht, is now being accused of plagiarism simply because it happens to fit the moment. Is the accusation of plagiarism being used as a weapon against dissidents?
Ja, das glaube ich. Also im Ausland wird es auf jeden Fall so gesehen. Ich war letztens
Yes, I think so. Abroad, that's definitely how it's seen. I was in France recently and did a podcast with a Brit, and he said right into the camera, in Germany, that's basically the standard way to get rid of people. That's what he said, as a Brit. And honestly, I think, once again, we have a kind of unique feature here in Germany. I also believe that in other countries, let's say Italy, Spain, or France, and I can judge that a bit, it's not like that.
Da kann ich so ein bisschen beurteilen, nicht so ist, ja. Also das ist ja ein sehr formales Kriterium.
Well, that's a very formal criterion, and there's always this kind of number crunching we apply here. Apparently a tried and tested method. But let me put it this way. The best tweet I saw when I was fired over plagiarism, the best one I still remember, someone tweeted, if Ms. Guérot had been a man, they would have accused her of Me Too. So for men, it's Me Too, and for women, it's plagiarism or whatever else. Anyway, there are these more or less standardized accusations like with Kakelman that always seem to work. Sexual harassment always works with men. Once that comes up, they're done. Or remember Edithy, child pornography during the NSU trial. You could really take another close look at what actually happened there. Anyway, sexual offenses, sexual harassment, those always work, and especially well against men. Plagiarism, I'd say, works both ways. We all know, for example, Theodor zu Guttenberg, who copied 32 pages from me. That's kind of funny, actually. On that Goody Plag site, there are 32 pages. One of my articles was copied in full by Theodor zu Guttenberg. I just wanted to point that out. And there are sources from about 40 other people on that Goody Plag, too. In my case, it's only about 1% citation errors overall. The proportions just don't add up at all.
1% Zitierfehler, ja. Also die Dimensionen stimmen ja auch überhaupt nicht.
Der Verfassungsrechtler Bockenförde.
Constitutional Judge Bockenforde once wrote that democracy is a form of government that cannot create the conditions it needs to exist. I take that to mean that democracy also depends on democratic awareness and civic courage. Do the labor court judges you've dealt with lack those qualities?
Den Arbeitsrichtern, mit denen du zu tun gehabt hast.
Ich persönlich würde das bejahen.
Personally, I would say yes. I would have liked to see that too, at least at the level of the Federal Labor Court. Because it's also a question of what kind of authority you have when you take a stand against a broader social current. I mean, if you're still, let's say, trying to build your career, you know what I mean, you might hold back. But if you're on the Federal Labor Court, you're around 60, your career is basically behind you, and you don't really have anything to fear anymore. You don't have to worry about being fired. So, in that sense, you're in a relatively secure position.
Maybe people at the golf club would look at you funny.
Yeah, exactly. But at some point, you have to weigh things, you know what I mean? I actually said it that way in my speech, too. I can still understand that a young judge at the Federal Labor Court in Bonn might not have had the backbone to stand up against public prejudice, and maybe I can still accept that at the level of the state labor court. But 3 years later, at the Federal Labor Court, with both time and distance from all that public outrage, it gets really hard to understand, especially there, where the judges, I'd put it this way, really have nothing to fear. Who's going to fire them just because they rule differently in my case? That's something you just have to swallow. And then, since you're quoting Böckenförde, well, it would be nice if we could just put everything on the judges, so to speak. But I really want to make it clear, I'm not here to criticize judges. I always try to see the person behind the role, no matter what kind of pressures they're under. And Böckenförde, who would be the Böckenförde of today? I just mentioned some of the distinguished scholars from the University of Bonn, Isensee, Ossenbühl, Tomuschat, and so on. Böckenförde belonged to an earlier generation, but he was truly an icon. These days, we don't really know any names anymore, where we'd say, this person or that person really stands out. So who, in a sense, carries on Böckenförde's legacy? Just because there once was a Böckenförde and a few others like him, Droth, or whatever those grand figures were called, and then a Habermas who has now also passed away, you knew back then, there, solid intellectual foundations had been laid. They were established in the universities. And the graduates from those places went on to work in the courts or in the newspapers. And back then you could say, everyone had a kind of backbone. And if you think about it now, right, we started this conversation with me trying to draw a line between a kind of beer tent camaraderie and a systematic shift. If we no longer have any of that, then it's exactly what Böckenförde talked about, a democracy that depends on something it can no longer guarantee, namely that it has responsible, self-reliant citizens. The engaged citizen, the educated citizen, both have basically been done away with. The thinking citizen, the one who feels accountable to their conscience and stands up for their civil rights. That's not what people do anymore. They've already been intimidated, they've been cowed. By now, people have realized, I don't dare to say that anymore. I just can't say it. Then they think, I've got 2 kids, I have to pay off my house, and so on. So, we're already deep in these social processes that show exactly what Böckenförde described, that a democracy can't create the conditions for its own existence, meaning it can't produce responsible citizens all by itself. People have to find that sense of responsibility on their own, stand up straight, have some backbone, and so on. That's the dangerous process we're in right now. I really think it's very dangerous, and it's not something you can just fix overnight. That's kind of like you can't stop an avalanche halfway down the mountain, can you? Yeah. And I just mentioned the idea of the school community. I'd really like to see that too. We talk so much about civil courage, and we also talk about all these microaggressions. So just to put that in perspective, this morning on Deutschlandfunk, today is April 29th, anyone can check it, there was some Green Party representative talking about this feminist issue. No means no. Now has to become yes means yes. So when it comes to this whole consent issue during sex, honestly, I have a real problem with the fact that we make such a huge fuss about microaggressions. We have these massive public debates about them. We put trigger warnings in theaters and so on. Meanwhile, there's a genocide happening in Gaza, there's a war in Ukraine, we're bombing Iran, on and on it goes. The big things aren't even being looked at anymore. Everyone's caught up in the microaggressions. Something has clearly shifted in our society. You know, that's what I mean.
Are these just diversion tactics meant to distract from the fact that, for example, the University of Bonn, the University of Kiel, and others have increasingly submitted themselves to market forces, that they've become more and more commercialized, moving away from academic freedom and toward the business-oriented, entrepreneurial use of science? Things like funding programs, temporary contracts, junior professorships, all of that leading to commercialization? Does that show, Ulrike Guérot, that she no longer serves us as a marketing tool? In that case, we might as well let her go.
Thanks for the question. I think now we're really getting to the core of it. Academic freedom also means freedom of science from money. Period. You mentioned third-party funding. I think this hollowing out through external funding streams is absolutely crucial. I've said in earlier interviews that, for example, the whole COVID situation wouldn't have happened if we still had fully funded or state-funded universities. We did in the 1980s. Back then, universities. Before we started introducing all sorts of other models like nonprofit corporations, private universities, and everything that's come up since then, were public institutions, and they were basically fully funded. You could say that, but it's expensive. You could also ask, what did we actually fund back then? Things like orchid sciences, or some sinologists studying the shape of flowers in Chinese, whatever, 14th century porcelain, and so on. Do we really have to pay for all that? Sure, you can do that. Every system has its flaws. I'm not saying everything was perfect back then. But today, universities have to chase every call, like Horizon 2020. Then there's a new call. What's trending in political science? Oh, populism. So everyone does populism. You only get funding if you do research on populism. And that's how you can finance your PhDs. If you stand up and say, I'd rather do something anarchic, well, that doesn't work. You can't get your PhD funded and so on. That means research is already being steered by the research question itself, even though science is really about curiosity. Science means, I see something, I'm curious, I don't understand it, and I want to explore it. That's what science is. But if I say, now we're all doing populism, oh, so now we're all doing populism, right? That's conformity. And of course, that creates homogeneity, because everyone ends up doing the same thing at the same time, and the whole research enterprise keeps moving forward in a kind of uniform way. I really see that as a serious problem. And why do I say that? Well, I've never made a secret of it. I've never claimed to be the best scientist. And I want to make that absolutely clear, also to the University of Bonn. Let me say it again. The job posting was about management, building up an institute, networking, media skills, yes. And science was one criterion, but just one among several. So I wasn't actually at the university. My entire so-called career after finishing my PhD in 1995 until 2016, when I got my first position at a university in Austria, for those 20 years I I wouldn't say outside of academia, but definitely outside the traditional academic system.
Außerhalb des klassischen Wissenschaftsbetriebes. Ich habe nie einen DFG-Forschungsantrag gestellt.
I never submitted a research proposal to the German Research Foundation. I worked in what you might call think tanks. I spent time abroad in Brussels, Paris, Washington, and other places doing what's generally known as applied science. That means consulting, studies, research papers, things like that. It was in a kind of para-academic space, a sort of pre-academic environment. And in that space, I was naturally connected with the media, with politics, and with academia, including universities. I actually met Habermas at conferences and had discussions with him. I sat in seminars in similar settings where I interacted with journalists, people from politics, from academia, and from business.
Von der Wirtschaft, ja? Also sozusagen interdisziplinär, wenn du so willst.
So kind of interdisciplinary, if you will. For example, and I mention this because it was important for my research, I worked quite a lot with Armin von Bogdandi. He's a legal scholar, still around in Heidelberg at the Max Planck Institute for European Law, but I wasn't a classic academic, sitting at a university and writing just one research project. I also had teaching assignments, again and again, all over the place. I taught at INSEAD, in Singapore, in New York, in London, in Paris, really everywhere. So I was always a bit broadly positioned, you could say. You might even call that an asset, a real advantage.
Kann man ja sagen, das ist ein Asset, das ist ein Vorteil, ja? Und dann komme ich nach 20 Jahren, also
And then, after 20 years, so from 1995 to 2016, I came back to the university in Austria. And I looked around and said, oh, so this is what a university looks like today. ECTS, Bologna process, more rigid structures, third-party funding, codes, managing curiosity. Yeah, I thought, well, that's interesting. Sorry, that was a long answer, but the short one to your question is this. A lot has really changed at the university in 20 years. And I think society truly has to face the question of what science actually is today, beyond dependence on external funding. In my view, we urgently need to get out of that. Urgently.
Die Universität Kiel.
The University of Kiel, its executive board, sent a message to all students and staff saying that travel to Russia remains prohibited. Leaving aside the fact that a university can't actually forbid that, can a university that issues such a statement even claim to be engaged in scientific work? Because science means discussion, exchange, confrontation. Is that still even possible?
Die Konfrontation. Geht das überhaupt noch?
Also eigentlich würde man darauf warten wollen, dass es einen klugen Juristen.
Well, you'd really expect that at some point, a smart lawyer in this country would take this to the Constitutional Court. We have a peace clause in our basic law. We have a mandate for international understanding. And actually, those are the legal aspects of it. So I keep wondering why no one has ever thought of challenging these absurd preliminary measures. We had the same thing at the University of Bonn. In 2022, we got a circular telling us to review all our research projects to see if there were any Russians involved. And if there were, we were supposed to somehow get them out.
Dann müssten die irgendwie rausbuxiert werden. Und wenn wir einen Ukrainer hätten, den wir einstellen sollen, dann sollten.
And if we had a Ukrainian we were supposed to hire, then we should go ahead and hire that person. And I'd say if there were a smart lawyer around, it would be worth checking legally whether that's even constitutional. But in the spirit of the Enlightenment, the European Enlightenment, that we, as Europeans, once committed ourselves to, art and science shouldn't be renationalized. What matters is the scientific achievement or the musical achievement. When we quote someone like Tchaikovsky or anyone else, we don't judge them by whether they're Russian or Ukrainian, but by whether the Nutcracker is a good symphony. So, the fact that we're basically scratching at the legacy of the European Enlightenment, well, scratching isn't even the right word. We've already let the crater cave in. I was just in Moscow. You know, my book's been translated into Russian, and I talked to a lot of people there. But by now, it's really come to the point where conductors, violinists, whoever it may be, are being conditioned. If you perform in Russia, you won't be performing at La Scala in Milan anymore. We're selling off the legacy of the European Enlightenment. It honestly brings me to tears that we're doing this. We who swore never again war, never again fascism, never again war from German soil, that we as Europeans carrying all the shame of the last century. Do you see what I mean?
Verstehst du, was ich meine? Ja,
That's also why, before the court hearing, you made a video appealing to the constitutional judges. What do you say in that video?
Was sagst du da?
Ja, also in dem Video, das ich unterteilt habe.
So in that video, which I divided into 4 parts of about 20 minutes each, I actually address the judges of the Federal Constitutional Court in a public statement. I do that because as a citizen, I believe I have the right to represent myself before almost any court, to make my own plea, so to speak. And then I thought, well, since we now have what Habermas would call a structural transformation of the public sphere through this platform economy, I mean, we're filming here too, making a video, and we can take it straight to the public. We don't have to knock on Deutschlandfunk's door and ask, will you broadcast this for us? We can just do it ourselves. That's exactly what Habermas would describe as a structural transformation of the public sphere.
Das würde ja Habermas bezeichnen als Strukturwandel der Öffentlichkeit. Und dann habe ich eben gesagt, im Sinne dieses Strukturwandels der Öffentlichkeit.
And then I said, in the spirit of this shift in public communication, I'm addressing the judges of the High Court directly, and that's exactly what I'm doing. I speak my own text, my defense, a personal plea, straight into the camera, in 4 videos, each about 20 minutes long. In them, I basically explain the timeline of the termination, very factually, I think. And I just go through, step by step, what happened, when, and how. The idea is to show the judges that what we're submitting as a constitutional complaint, that I wasn't heard, that no experts or witnesses were called, that nothing we submitted was even acknowledged, to show all of that clearly.
And you appeal to the judge's conscience.
Nein, ich rede den Richter nicht ins Gewissen.
No, I'm not trying to appeal to the judge's conscience. What I'm saying is I'm expressing that in my view, at this point, it's really all about them. And that's something you have to understand. I've just gone through a 3-year trial, and that was exhausting. You kindly said in your introduction that I lost my life and built a new one. I'd put it this way. I lost one life and got another. Anyway, it wasn't easy. It was, in fact, character assassination and the destruction of my livelihood. From one day to the next, no salary anymore. Anyone can imagine what that's like. So anyone sitting here listening to this video, you get several thousand euros at the end of the month, and from one day to the next, it's gone. I'm not saying you can survive that. It's happened to a lot of people. And I'm also including everyone who went through something similar during the pandemic. There were so many people who lost their livelihoods, so many restaurant owners, small businesses, the lower middle class, and so on. So I'm not trying to claim that my case is unique. What I'm really saying is that it's almost become normal for us to systematically destroy people's livelihoods here in the Federal Republic of Germany, a country that once promised to be a social state. But I tell the judges that I've had time to, so to speak, literally survive this whole trial. Building a new life for myself was really exhausting. Above all, the financial side is only one part of it. You can have your livelihood destroyed without being defamed, and you can be defamed without losing your livelihood if you happen to have inherited something. But having both at once is really tough, because my constitutional complaint is also about wanting to be rehabilitated. Money is one thing, but I did not act with deceitful intent. And this accusation of fraudulent deception, it's still out there. It's even on Wikipedia. It doesn't just affect me, it affects my children and potentially my grandchildren. So yes, that's been exhausting. That's why I say in my statement, Your Honor, I'm kind of through with all this. But my case, as many lawyers have pointed out, is apparently so clear, legally so clear, and in terms of the Constitution, so damaging because of this systematic legal shift and everything that comes with it, that the real question is my dismissal from the university really that important? Am I personally so important that the Constitution has to be bent for it? And at that point, it's really about you, whether you're willing to allow the Constitution, which you're supposed to protect, to be bent.
Das sie ja eigentlich schützen sollen, ja? Und ich glaube, das ist meine Message auch. Danke für dieses Video, die ich sende.
And I think that's really my message here. Thank you for this video I'm sending. It's not about me anymore. Whatever that was, it wasn't easy, but it's over. Now it's about something else, about whether my personality, my person, should somehow resolve a kind of systematic shift in the legal system that opens the door to arbitrariness in legal doctrine. And at one point in this video, I say no one, Honorable Court, no one can want that, least of all the judges of the Federal Constitutional Court. So I hand this over to you and say, it's not my thing anymore. I'm not here, so to speak, employed to protect the basic law.
Angestellt, ja? Aber die Richter des Bundesverfassungsgerichtes sind zum Schutze des Grundgesetzes.
But the judges of the Federal Constitutional Court are, so to speak, employed to protect the basic law. Employed, yes, civil servants. And at this point in the video, I quote Václav Havel. In fact, it's from the first video, where he said back in 1989 in a courtroom that he hoped the state authorities, let me recall the quote, would stop behaving like the little girl who smashes the mirror, thinking it's to blame for how she looks. And yes, I think that's exactly the point. I'm actually grateful for this video, and I'll make more of them, because this really matters to me. So I may be on the outside now, but we're going to save the legal framework of the Republic.
Aber wir retten jetzt die Rechtssystematik der Republik.
Professor Ulrike Guérot wehrt sich.
Professor Ulrike Guérot continues to fight back against defamation and the destruction of her livelihood. She's taking her case to the Federal Constitutional Court and keeps standing up against what she sees as the erosion of democracy and the basic law. For that, we say thank you. Here at Against the Current, we present viewpoints and perspectives that the propaganda media choose to hide.
Welche die Propagandamedien verschweigen.